Greetings, folks. I welcome you back to Inquisitive Bibliophage. Without any trepidation, I will get right into the text. Again, they take our jobs. And here goes the introduction. Today's immigration debate is rife with myths, stereotypes, and unquestioned assumptions. I, and we all, hear remarks such as, immigrants take our jobs and drive down wages. Why don't they learn English? Or, I'm not against immigration, only illegal immigration. After 20 years of teaching, writing, and organizing about immigration, it's clear to me that many of the arguments currently being circulated are based on serious misconceptions, not only about how our society and economy function, but also about the history of immigration, the law, and the reasons for immigration. All you have to do is read the papers or listen to the radio to notice that people seem to be extremely distraught and angry about immigration. Immigrants are blamed for a host of social ills and compared unfavorably to previous generations of immigrants. Since they are legally deprived of many of the rights that U.S. citizens enjoy, including the right to vote, elected officials and the general public can marginalize, blame, punish, and discriminate against them with little repercussion. Non-citizens make easy targets and convenient scapegoats. A lot of our assumptions and opinions about immigration today are based on a set of beliefs about this country's past. These beliefs are formed by our social studies and history classes, by our textbooks, by our politicians, and by our media. Indeed, they are so pervasive that they almost permeate the air we breathe. Yet they are also fundamentally distorted. They represent a sanitized version of history that can undermine our ability to analyze the world we live in today. In analyzing the issues surrounding immigration today, this book will often turn to the past to revise some of the fallacies that have shaped the way we view our society. Most U.S. citizens believe that this country is founded on principles of equal rights. They acknowledge that throughout history, many groups were excluded from access to rights: Native Americans, people of African origin, women. But the story of U.S. history is generally told as one of gradual expansion of rights to new groups of people, until finally, with the civil rights legislation of the 1960s, the last remnants of discrimination and exclusion were presumably removed. To those included in the circles of rights, the exclusion of others has always seemed justified, so much so as to be virtually beyond the bounds of discussion. When the Founding Fathers wrote that all men are created equal, it was quite obvious to them that women were not created equal to men, and that all men meant white men. When Patrick Henry reportedly declared, "Give me liberty or give me death," he assumed that liberty was something reserved for whites. A slaveholder himself, Henry admitted that slavery was morally problematic. But Henry's understanding of the discrepancy between his words and his deeds never led him to act differently, notes sociologist James Lewin. I am drawn along by the general inconvenience of living here without them, Henry explained. In every generation, people have found rationales for systems of social and legal inequality. Native Americans had no rights in the new country, so their land could be taken for white settlement. Africans had no rights, so it was all right to enslave them. Women had no rights, and their labor was generally unpaid. Contract workers had few rights, and their labor was underpaid. Immigrants, as well as workers in other countries, have also been deprived of rights, yet their low-paid labor provides the cheap products that our economy depends on. Today, a large and growing portion of our population lives without the full rights of citizenship. Non-citizens work, pay taxes, go to school, and raise families. They live in our cities and towns. They participate in religious, sports, and community events. They serve in disproportionately large numbers in the military. But both the law and popular opinion deem them somehow different from the rest of us, and not eligible for the rights and privileges that 90% of the population enjoys. As of March 2005, more than 35 million people, a little over 10% of the total U.S. population, were foreign-born. Most of these people had legal permission to be here, but about a third of them did not. About 1/3 of all foreign-born people, documented and undocumented, came from Mexico, the largest source of immigrants. Over half came from Latin America and the Caribbean as a whole, including Mexico. Another 18% came from East Asia. The top 10 sending countries were Mexico, China, the Philippines, India, El Salvador, Vietnam, Cuba, the Dominican Republic, Canada, and Korea. During the 1990s, the number of immigrants increased rapidly. In 1990, only 19.8 million reported foreign birth. In 2000, the figure was 31.1 million. These figures do not include the 3.4 million Puerto Ricans who lived in the continental United States according to the 2000 census. They are U.S. citizens, although they are also Latin Americans. Although one wouldn't guess it from the increasing anti-immigration agitation in the 2000s, immigration actually slowed significantly after the end of the 1990s. Nativism, or anti-immigrant racism, responded as much to other trends in society as to the actual number of immigrants coming in. The current influx of immigrants is often compared to the last large and sustained wave, which occurred between 1860 and 1920, when the rate of foreign-born persons in the population ranged from 13 to 15%. Because the total population was smaller, this higher percentage represented a smaller number of people. Prior to the 1980s, the highest year for the foreign-born was 1930, when 14.2 million people reported foreign birth. Most of these immigrants came from Southern and Eastern Europe. During the 1860 through 1920 immigration wave, as well as during that of the late 20th century, immigration was accompanied by nativist reactions. Nativists worried that immigrants would fail to assimilate, would undermine the perceived linguistic, cultural, and racial homogeneity of the country, would take American jobs, and would lower wages. Commentators in various forums warned that the newcomers would bring disease and crime. Today, Arthur Schlesinger worries about the disuniting of America, while Samuel Huntington fears the challenges to American national identity. They seem to be echoing the California Attorney General who wrote in 1930 that only we, the white people, found America first, and we want to be protected in our enjoyment of it. While there are many parallels between the two waves of immigration, there are also some significant differences. Ideas about race have changed significantly over the course of the century. In the 19th century, overt racism was widely acceptable in the mainstream. Today, it is not. By the late 19th century, the Academy sought to provide biological and scientific research proving the existence and nature of racial difference. Scholars of all stripes dedicated themselves to classifying the globe's population according to their supposed racial characteristics. Europeans were divided into the Anglo-Saxon race, the Slavic race, the Mediterranean race, and many others. Popular and legal thought varied as to whether the latter belonged to the white race or not. The relationship of race to nationality has shifted in slippery ways, and is in fact still in flux. Ideas about race in the United States have been shaped by immigration and have also shaped the way people think about immigration. Every U.S. census has used different categories to identify race. Until 1930, Mexicans were white. Then, the 1930 census designated Mexican as a separate race. Today, most people inside the Academy and outside agree that race and ideas about racial difference are social constructs rather than scientific facts. Even the census itself acknowledges that racial categories are socio-political constructs and should not be interpreted as being scientific or anthropological in nature. The U.S. economy has changed drastically between the two periods of immigration. In the 1890s, the United States was industrializing rapidly, and most new immigrants went to work in the mines, mills, and factories of the new industrial economy. In the 1960s, the country was undergoing deindustrialization, and the mines, mills, and factories were closing, creating a rust belt in the very regions that had previously been a magnet for immigrants. The deindustrialized economy still created a demand for immigrant workers, but in the service industry, cleaning, all kinds of cleaning, as one immigrant worker who ran his own small house cleaning business described it to me, immigrants now clean houses and office buildings. They clean hospitals and restaurants. They clean people, clothes, and cars. The new wave of immigrants was also different because they came from countries in Latin America and Asia that had a history of U.S. interventions and political and economic domination. In this respect, post-industrial immigration to the United States was not unique. European countries were experiencing the same phenomenon. Industrialization had been accompanied everywhere that it occurred in the late 19th century by colonial expansion, military, political, and economic. Sometimes this expansion took the form of direct colonial rule. Sometimes it consisted of informal means of control. Deindustrialization in the late 20th century was accompanied by immigration from former colonies. These different events were part of an interconnected historical process. And to understand the differences between the two waves of immigration, we need to understand the entire historical process. These issues of race and the global economy were also interrelated. People who were colonized were considered racially different in ways that left very deep roots in the modern world, and colonialism also left long-term economic consequences. When people of color from the colonies migrated to Europe and the United States in the late 20th century, these deep racial and economic colonial roots were coming to the surface. Many societies have struggled with the question of what makes a person eligible for rights. Does everybody have rights simply by virtue of being human? Or are rights restricted to a select group of people in a society who are defined as citizens? And if rights are dependent on citizenship, how is it decided who is a citizen? After World War II, there was a widespread repudiation of the kind of legalized discrimination that many believed led to the horrors of Nazism. The Universal Declaration of Human Rights, passed by the United Nations General Assembly in 1948, upheld the idea that there was no justification for governments excluding certain groups of people from rights. The Declaration asserts in Article 2 that everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind, such as race, color, sex, language, religion, political, or other opinion, national or social origin, property, birth, or other status, and in Article 6 that everyone has the right to recognition everywhere as a person before the law. The Declaration is unambiguous. Rights apply to all people. The Universal Declaration embodies an expansive notion of rights, in addition to many of the rights protected by the U.S. Constitution and Bill of Rights. The Universal Declaration defines and guarantees social and economic rights like the right to work, the right to equal pay, and the right to education, food, housing, and medical care. The U.S. Constitution is a bit more ambiguous about what rights belong to all people and what rights belong only to citizens. The law has always been utilized to exclude some people from rights, often to the advantage of employers, who can then exploit those who are excluded. When we look at the past, we generally decry exclusionist ideas and laws. The Nuremberg laws, for instance, excluded Jews from rights in Germany. There is no real logic to excluding people from rights based on immigration or citizenship status. Citizenship was based on race during most of the history of the United States and has historically been employed as a way to justify discrimination. The U.S. Department of Homeland Security provides a civics lesson to those people who are eligible for citizenship. Prepare for the test they'll have to take as part of the process. One question reads, whose rights are guaranteed by the Constitution and the Bill of Rights? The answer is unequivocal: all people living in the United States. The lesson goes on to elaborate. One reason that millions of immigrants have come to America is this guarantee of rights. The Fifth Amendment guarantees everyone in the United States equal protection under the law. This is true no matter what color your skin is, what language you speak, or what religion you practice. The 14th Amendment, ratified after the Civil War, expanded this guarantee of rights. No state could be able to abridge or block the rights of any of its citizens. The reality is a bit more complex. United States law has always been, and still is, restrictive about who deserves rights. Until the Civil War, federal statutes took for granted and upheld the notion that citizenship and rights should be based on race, and that rights depended upon citizenship, which was reserved for white people. The distinction was not between the native-born and immigrants, as it is today, but rather between whites, who were citizens, and non-whites, who were not. The 14th Amendment passed in 1868. For the first time, extended citizenship to all persons born in the United States, except Native Americans. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The amendment thus expanded citizenship by partially separating it from race for the first time. Before this, citizenship was restricted to whites, and rights were restricted to citizens. But citizenship was not completely separated from race yet. First, the subject to the jurisdiction thereof clause excluded Native Americans, even those born in U.S. territories. Second, anybody born in the United States was automatically a citizen, but only white people could be naturalized as citizens. The 1817 Naturalization Act extended the right to naturalize to Africans and people of African descent, but they were not the only non-white people in the United States. Citizenship was particularly denied to Asians. By 1882, they were prevented from coming to the United States at all, in part to ensure that nobody of Asian descent would gain citizenship by virtue of being born here. Chinese people were not permitted to naturalize until 1943. Even then, they were subject to an immigration quota of 100 per year. Filipinos and Asian Indians were granted the right to become citizens in 1946, and the Asiatic Barred Zone, established in 1917, was finally abolished in 1952. It was not until 1965, however, that the 100 per year quotas were lifted for Asian countries. The 14th Amendment's second sentence extends rights even to more broadly than the first. No person, apparently, citizen or non-citizen, can be denied equal protection under the law. The apparent contradiction in the amendment left it up to the courts to rule on what it meant in specific cases. The U.S. Supreme Court has given contradictory rulings. Two important decisions argued that citizenship status could not be used to deprive people of rights. In 1971, Graham versus Richardson prohibited states from discriminating against legal immigrants in granting welfare benefits. In 1982, Plyler versus Doe ruled that all children have a right to public school education, regardless of legal status. Other decisions, though, allowed states to discriminate, and the 1996 Welfare Reform incorporated unambiguous discrimination against legal immigrants. Most Americans assume that voting rights and citizenship are identical, and that restricting voting rights to citizens is natural and reasonable. But even this relationship is far from clear-cut. For a good part of our country's history, explains political scientist Ron Haydock, voting rights were determined not by citizenship, but by whether or not one was white, male property holder. Thus, women and post-emancipation blacks who were considered citizens could be denied voting rights. In fact, alien suffrage actually buttressed the privileging of propertied white male Christians. The Constitution allows states and municipalities to determine voting criteria. Until the 1920s, many of them permitted non-citizens to vote. It was in the context of particular political struggles and large-scale immigration after 1850 that states began to exclude non-citizen immigrants from voting. Haydock explains, in the Civil War era, Southern states resented immigrants' opposition to slavery. In many states, wartime hysteria and the Red Scare after World War I made Americans want immigration to prove their loyalty before receiving the privilege of voting. And in others, like Texas, during the women's suffrage struggle, ending the immigrant vote was a way for political status quo supporters to counteract the broadened electorate that came with the 14th Amendment, voting rights for African American men, and 19th Amendment voting rights for women. Restrictions on immigrants' voting rights went along with other restrictions, literacy tests, poll taxes, felony disenfranchisement laws, and restrictive residency and voter registration requirements, all of which combined to disenfranchise millions of voters. Many European countries and even municipalities in the United States allow non-citizen voting as a matter of course. Non-citizens live in communities, they pay taxes and use services. Why should they be excluded from political participation in the place where they live? Conversely, some citizens are denied voting rights. In most states, citizens who have been convicted of a felony cannot vote. Residents of Washington, D.C. could not vote in presidential elections until 1964, and Puerto Rican residents still can't. And citizens who live in these two areas have no congressional representation. An analysis of the 2000 census showed that in 85 California cities, over 25% of the adult population is disenfranchised because they are not citizens. In 12 of these cities, non-citizens are over 50% of the adult population. A substantial number of persons who contribute to our economy and our government's revenues are being denied political representation, explains the General Counsel for the Mexican American Legal Defense Fund. If the 14th Amendment is taken literally, then it is routinely violated in the United States today. Non-citizens are openly denied equal protection, and some of them, those who are undocumented, are denied any protection under the law. Their very existence is termed illegal. In many ways, their situation is comparable to that of African Americans prior to the 1870s, and again after the 1890s, when Reconstruction's attempts to make citizenship real for African Americans were unraveled. Undocumented persons and even legal immigrants may be physically present in the United States, but they are not treated equally under the law. Just as in every period of U.S. history, the law today discriminates by excluding large sectors of U.S. society from its protection and from the concept of equal rights, rather than race, ethnicity, or gender, which have been discredited as reasons for excluding portions of the population from access to citizenship. Today, the dividing line is generally place of birth. Unlike in the past, there is no blanket prohibition on citizenship for any group of people. Nevertheless, many people in the United States are denied the right to become citizens and denied the rights that go along with citizenship. Just as it seemed obvious to those in power in the past that race, ethnicity, and gender were legitimate reasons to exclude portions of the population from rights. Many American citizens today believe passionately in the need to divide the population between citizens and non-citizens, and immigrants between those deemed legal and those deemed illegal. That those classed as the latter categories should be denied rights, and that large groups of people should be denied the right to become citizens or to become legal, is considered self-evident. Although the exclusion itself is rarely questioned, resentment against immigrants and attempts to further marginalize them are rampant in today's society. The suggestion that non-citizens too are created equal is virtually absent from the public sphere. However, claims that immigrants take American jobs, are a drain on the American economy, contribute to poverty and inequality, destroy the social fabric, challenge American identity, and contribute to a host of social ills by their very existence are openly discussed and debated at all levels of U.S. society. In a series of short chapters, this book seeks to dismantle the myths that inform the major debates about immigration in today's United States, to address issues ranging from America is a nation of immigrants, to immigrants take American jobs. It draws on immigration history, critical race studies, labor history, Latino and Asian studies, analyses of globalization, and other academic areas to show how the parameters and presumptions of today's debate distort the way we think about immigration. Each chapter seeks to identify and challenge the assumptions that underlie some of the prevailing arguments about immigration, The book challenges the way we understand U.S. economic and immigration history. I argue that since before this country was founded, its economy has been global. The prosperity of some within our borders has always depended on the cheap labor of others from both inside and outside our borders. This cheap labor has been justified and guaranteed by excluding certain workers from the categories of people who are afforded rights. Although race is seldom directly invoked in anti-immigrant discourse today, I argue that race is so deeply tied to the ideas about citizenship and immigration that it is central to the discussion. I conclude with an attempt to imagine what a humane immigration policy would look like, and how creating a humane immigration policy would connect to other changes at a national and global level. Please stay tuned for part 1 of the text. I thank you for your attention.